Good morning and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, Pennsylvania, and I am right here with you every Sunday from 8 to 9 a.m. right here on this station to bring you, the landowner, the information that you need regarding natural gas development here in Pennsylvania. At the Clark Law Firm, my focus is on landowner, property owner, royalty owner representation. Please remember, I have not, I do not, and I will not represent gas or pipeline companies. I represent the Pennsylvania landowner for such items as, of course, oil and gas lease negotiations, reviews, consultations, pipeline right-of-way, water line agreements, have worked on, negotiated, consulted with pipeline agreements with over at this point 70 different companies across Pennsylvania to give you an idea of what is out there. Royalty and royalty deduction issues. Breach of contract, breach of lease, breach of pipeline, estate planning, property selling relative to oil and gas, you name it relative to oil and gas, surface use agreements, damage releases, well site agreements. Again, those royalty issues, which we're going to talk today, royalties. So put on your thinking cap, hit record. Well, actually, you know what? Remember, we don't need to hit record. Some of these concepts can be tough. You're hearing them for the first time. They go past you. You say, boy, I wish I could hear that again. Well, you can. Go check out our websites. We'll have today's show will be up on Monday morning. So you can go to the websites, pagasleaseattorney.com, pipelineattorney.com. This week's show will be up on Monday, as are many, many hours of radio show. I've been doing this show since 2010. 2010. We're coming up on our anniversary, 2010. So go check out prior radio shows, pagasleaseattorney.com, pipelineattorney.com. Also, I say this, even if you're not looking for representation, but you're looking for information, check out pagasleaseattorney.com. Check out pipelineattorney.com. Listen to prior radio shows. The key is to raise the bar of information for you, the Pennsylvania landowner. We want to raise the bar across the board, and I believe that this radio show and the websites help to do that. Whether we ever talk, I'd love to hear from you. I'd love to represent people that need assistance, and if we can help you, we would love to do that. But even if you're not looking for representation, get information. And as I say, if we're not right for you, call someone who is. But we have to stop simply relying on what we're being told by the company who is on the other side, by the company landman who, as we all know, does not work for you, works for the company. So we need to get you the information that you need, because I've been doing the show since 2010, and people still are routinely, very common, signing bad agreements, and we have to stop it. We really do. So if you're looking for representation, want to learn more, learn about reviews and consultations, which usually take only an hour to two, give us a call, 570-307-0702. That's 570-307-0702. I do these reviews, consultations, and obviously representation for landowners all across the state of Pennsylvania, the Commonwealth of Pennsylvania. You can call 570-307-0702. learn about what we do. I represent a bunch of hunting clubs, individuals. Just did a lease for a gentleman. It was a 0.87 acre lease. Also have recently done leases for hundreds and hundreds and hundreds of acres. So just don't be afraid to reach out and call. Don't be afraid of the distance. We do a lot of reviews, consultations, by telephone, in office. You're always invited to come here, but please don't worry about distance. The gentleman who I just represented with less than an acre, he actually resides in Florida, and the property is in the corner of southwestern Pennsylvania. So do not be afraid of distance. Give us a call, learn about what we do, and see if we're right for you. 570-307-0702. Okay, you're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Let's dive into it. I have a lot to talk about today. And as always, whether you're leased or considering a lease, whether you may be offered a lease in the future, maybe your lease is expiring, this show is going to be very important. I'm going to talk about royalty language in leases, royalty language in addendum forms that are offered or added or negotiated, and we're going to talk about the practical impact that you may see as a result of different types of royalty language. This is an extremely important show. There are many landowners, and right now in Tioga County as an example, who are getting lease offers by multiple companies. Potter County as well. Again, just did a lease in Susquehanna. We have others pending in southwestern Pennsylvania, and a lot of activity in Tioga and activity in Potter County as well. So I want to talk about some of this lease language. We want to clarify some questions that I know that a lot of people have out there, but we also want to really break down the types of the different types of royalty language and provisions that are out there. And so you can understand, when you look at these different types of provisions, you can understand maybe a little bit more what the companies are getting at, where the loopholes may be, and how you then are more educated as you go forward on these issues. Because people, as the landowner side, are not getting this information. So we want to share it with you. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can always call the office, 570-307-0702, to learn more about representation, 570-307-0702. But make sure that you're tuning in every Sunday right here, 8 to 9 a.m. on this station for All Things Marcellus. Okay, let's get into it. So let's talk royalty. Now, let me set a little bit of a basic background. So in gas leases, every gas lease has a royalty provision within the body of the lease. Here's a little clue, everyone. You are given a gas lease, which is the body, the form lease by the company. Then there may be additional terms added by way of an addendum. An addendum, which is a separate piece of paper or pieces of paper, sometimes called riders in insurance policies, but they're additions to the form agreement presented by the company. And if you are simply signing the form agreement presented by the company, you're probably making a mistake. Probably a significant mistake. Very possibly an extremely, extremely significant mistake. So hopefully we know that we don't want to just sign the form agreement in almost all cases. Remember, not specific advice for anyone. There may be unique cases where you need to do that, but boy, my opinion, that is unique. Then remember that you then negotiate the addendum terms, or you try to have additional terms added by way of addendum. The companies aren't stupid. You say, hey, I'd like to have this, whatever that provision may be. Company provides you something, provides you language. Well, that you can bet that language has probably been drafted because the company prefers that language as opposed to other language addressing that issue. Now, great example is royalty, and that's what we're going to talk about today. But there's many other examples. My point is, the overall point, and I don't want this to get lost, the overall point is just because you have addendum terms added to the agreement, just because you asked, you negotiated, and you had additional terms added to the agreement, that may not be enough. That language may not cover what you think it does. You may focus on the heading or the words above the language. For example, royalties without deduction. That could be a heading, and you say, all right, royalty without deduction, that's what I want. I'm all set. Woohoo! Where do I sign? That, you got to be careful, because just because the heading says royalty without deduction, that may not mean what you think it means. And many, many times it does not. And that's where you need somebody on your side telling you what this language means, how it will be interpreted, and how it may impact you going forward, and how it may have a substantial impact on you going forward. You need to understand those things. And that's where you need to go out and you need to get someone who's going to assist you, work for you, explain these things to you, not somebody who's working for the company. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, you can call us anytime, 570-307-0702. One thing I want to touch on quick, multi-unit well consent forms. Multi-unit well consent forms. Offered up by Cabot, Susquehanna County. You get that. Encourage you to give us a call, review, consultation, see if we can help you. They usually take an hour, maximum typically 2 hours. These documents can have a big effect. Give us a call, see if we can help you, see if we're right for you. 570-307-0702. Stop signing. Get assistance. Let's make sure that you know what you're signing and you know how it's going to impact you moving forward. Multi-unit well consent forms from Cabot. Give us a call, 570-307-0702. Okay, let's go now. What I'm going to do here is we're going to set a standard, and what I'm going to do is I'm going to read a royalty provision or part of a royalty provision, and this is actually from a SWEPI LP, which is owned by Shell, lease. So this is from their form lease. So this is going to be our starting point. Then we're going to look at some other language. We're going to look at some addendum. We're going to look at some sample pricing, and we're going to become informed and educated and have a much clearer idea how this stuff works by the end of the show. So stay tuned. And remember, if you have to leave and you can't make it or you miss something, just jump online. You can go to pagasleaseattorney.com, pipelineattorney.com. Go there Monday morning, and you'll be able to check out the show. Go there Monday by noon, let's say that. And you can check out today's show and many others on the websites. Okay, so here we go. Here's a sample from a SWEPI lease. This is their form lease. Okay, this is a document that they present to you, and this is just a portion. I'm going to not read the whole thing, but I'm going to read a portion of this. So, okay, this is the royalty payment, item number 4, saying that for all oil and gas, and I'm going to paraphrase, the company's going to pay you 1/8, which is 12.5% royalty of the proceeds actually received by lessee. Now, when you see words like proceeds actually received, revenue realized, things like that, those are red flag indicators that means that you're going to get paid royalties, what we would typically think of as after deductions. Proceeds received, revenue realized. Those are buzzwords which may sound good or look good in the document, but what they're really saying is, hey, you're going to have the deductions taken, and we want to try to avoid that when possible. So now I'm going to jump though. So basically the beginning part talks about, hey, we're going to pay you 1/8 royalty or 12.5%. Again, this is a form, and you should seek to negotiate it. Then it goes on then, and this also says, hey, look, we're going to take deductions, that we're going to subtract and we're going to take deductions for items such as gathering, transportation fees, dehydration, and compression. Again, virtually every form lease is going to say that. So what are we going to do? We're going to try to negotiate that in all cases. But then this is the last part that I want to talk about here before we get to the first break. So then it goes on, and you've heard me talk about this before, but it goes on. The other part is where are they going to sell the gas? Who are they going to sell the gas to? How are they going to be marketing this gas? So this says that should the company sell or transfer or otherwise dispose of the gas to an affiliated company, then the company shall receive as its royalty 12.5% of the higher of one or two things. Number one, the sales proceeds received by the company from the sale of the gas to its an affiliate at or prior to, that's very important, at or prior to the first point downstream of the leased premises, generally recognized in the industry as a common point of sale. That's number one. And I'm going to tell you, I don't think that's going to be with the price that you find that you're going to get paid, because it's the higher of these two things. And the second one being that the average daily published price for natural gas at the nearest interstate pipeline. Okay, let me go back real quick. So again, you're going to get 12.5% royalty of one of these two things. So the company sells it to an affiliated company they own, which we need to watch out for. If they do that, then we say that you're going to receive the sales proceeds received by the company from the sale of that gas to the affiliate. Well, they're going to control that price. So they very well may, I stress may have a lower price than what you'd like to see when they're dealing with themselves in a non-arm's length transaction. We want to see market transactions if possible. So you're probably not going to see them sell it to themselves at a super high price. Now I'm talking generally. Okay. Or number two, the average daily published price for the sale of natural gas at the nearest interstate pipeline. So look, that can look attractive because you say, well, all right, if you're going to sell the gas to yourself, then we need to protect ourselves so you're not selling it to yourselves at a low amount below the market, because then you can pay us less royalties. Meaning, say the market was $2, but you sell it to yourself as at $1, then you pay royalties on $1 gas instead of $2. Since, this is hypothetical, you own as the company, the affiliated company, you still reap the profits from these transactions, but you're able to pay the landowner $1 royalty on $1 gas, instead of maybe what the true market is, in my example, $2. We need to be careful. We need to watch out for affiliated sales. So I'm going to wrap this up here just for this part. So we have this lease saying that they're going to give you either the price essentially that they receive from their affiliate, or they're going to give you the index price at the local pipeline. So the average daily published price for natural gas at the nearest interstate pipeline, regardless of where your gas is sold. That's where you're going to be priced at. One of those 2 points, but that's the index price, not the sales price of your gas, the index price. And I'm going to talk more about that the next section. But the last part, here's the other kick in the gut. Both of these methods, whether it be the affiliated sale price or the index price, are subject to the company's right to deduct from your royalty post-production costs. So, company can sell it to themselves at the wellhead, set that price by using an index somewhere locally, which may be lower than a market that you might normally obtain. Maybe. Again, these are maybes. And then take deductions from the index price. So we got to be careful of that. And those are things that you have to know. Now, you may still elect to go ahead and sign, but these are things you have to know. And then we see if we can improve this. So this is a good starting point. We have a lease that allows for deductions in every way. We have a lease that allows for affiliated sales, and we have a lease that says if you sell it to an affiliate, the company either gives you that price or the company will use an index price or an average daily price at a nearest pipeline point. So let's work off of that. Now remember, show not specific advice for anyone. We're just taking some language and we're going to learn from it. And that's what we're going to do when we come back after this first break. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, Susquehanna residents, you have a Cabot multi-unit well consent request form. Give us a call, see if we can help you out. Reviews, consultations, these things can be more complex than you think. 570-307-0702. So whether it's a multi-unit well consent or any other matter, give us a call, see if we can help you. 570-307-0702. And remember to tune in again, 8 to 9 every Sunday right here in this station with me, Attorney Doug Clark of the Clark Law Firm. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember to join me 8 to 9 a.m. right here in this station. You have a multi-unit well consent, any other oil and gas matter, give us a call, see if we can help you. 570-307-0702. Okay, quickly resetting. Went through a sample lease. Now remember, not specific advice, not picking on any companies here. We're trying to understand this language, how it may be interpreted, and we're talking about the royalty language right now in the form agreement. Now, quickly to summarize, essentially as a summary, the agreement that I just went over, the royalty language, allowed for first document we went through. This was a SWEPI lease. My opinion, allows for complete and total deductions of post-production costs and allows for the company SWEPI to sell to an affiliated company as early as the wellhead and then either pay royalty based upon that transaction price or to use the average daily published price at a nearest pipeline point. So you can use one of those two prices, which I think you're going to find is typically going to be the average daily price because they have to use the greater of the two. Then remember, even though your price may be set using an index from a local interstate pipeline price, it still is subject to deductions for post-production costs like gathering, transportation, compression and dehydration, and so on and so on. You need to know that. Now again, not telling you sign, don't sign, or anything like that. I'm saying you need to know that. Now let's turn to another example. This is a lease sample form lease from EQT Production Company. EQT, very active in southwestern Pennsylvania, and EQT also active in north central Tioga, active in that area now. Their form lease, paragraph 3A, and the one that I have, and this again, form lease that they present to the landowner, says that they shall pay you a monthly royalty of, in this particular case, we'll just change the number. We'll say 15% of the net proceeds, net, meaning after deductions, from the sale of oil and gas produced from the leased premises. Goes on. Again, look, they say it. After deduction for cost incurred by the company or its affiliates for transportation, taxes, including severance, gathering, processing, and line loss. Then again, so this is when this happens to be the oil, but same principle, gas, 15% of the net proceeds from the sale of the gas sold from the premises after deduction for cost incurred by the company or its affiliates for transportation, and goes on again, taxes, gathering fees, processing fees, line loss, and compression. So, summary, this is saying that they're going to pay you this 15% royalty, but they're going to take deductions. And also, if they sell it to an affiliated company and that company incurs fees for transportation, gathering, compression, dehydration, and so on, those fees will also can be charged your rate to you as well. So, bottom line, totally different way to write this, but saying that, hey, look, they can clearly sell to an affiliate and you're subject to deductions, whether it's these deductions are incurred by the gas company or the affiliate that they sell the gas to. Quick example, gas comes out of the ground, company sells it immediately to an affiliated company which they own, then that company transports the gas and goes out and sells it. This is saying that that affiliated company, as they take the gas in the wellhead and they incur pipeline charges, transportation, gathering, and so on, they can charge you your share of those costs. But it's also telling us, hey, look, they're going to sell to an affiliate, or they may, and practice tells us that they're probably going to. Then also ask them if you can get rid of that language. And you're going to find out they're going to push back like crazy because, my opinion, they want to sell to an affiliate. How is that price going to be calculated? And these are things that you must watch out for. They can be extremely impacting on your royalty payments. Now, again, not telling people sign, don't sign. You need specific advice. You need to go over these things. But what you need to know is that these issues exist. You need to know how they may impact you. You need to see if you can change this language to minimize any negative consequence you may have. And by doing so, you can maybe improve the agreement, maybe improve it significantly, or maybe you can't, but you understand where you are, you understand the pros, the cons, and you may decide, hey, look, I'm going to do this anyway. I'm going to wait to see if this improves. There are many different factors that you must really look at when you're actually going to make your decision. And we're not talking about everything today. We're talking about royalty issues. So it's a piece of the puzzle, and it's a darn big piece. But there are other pieces. So remember, this isn't specific advice. It's information to get us thinking and get you on the right track and to make sure that you understand, hey, there's a lot we need to think about. This is All Things Marcellus, and you're listening to me, Attorney Doug Clark of the Clark Law Firm. Represent landowners, Pennsylvania landowners, royalty owners, oil and gas matters. Give us a call. See if we can help you. Any related issue. 570-307-0702. Cabot Multi-Unit Well Consents. Give us a call, learn about reviews and consultations, see if we can help you. 570-307-0702. And join me every Sunday from 8 to 9 a.m. right here in this station. Okay, so we want to regroup here for a second, make sure we're all on the same page here. So we've went through 2 sample lease forms. Now, we didn't read them all verbatim. We're going through to get these concepts out there. First form allows for these affiliated sales, meaning the gas company that produces the gas, your big guys, your Shell, your SWEPI, your Chesapeakes, your Chiefs, your Cabots, your EQTs, your Range Resources, and so on and so on. Those guys producing the gas, then selling the gas, often immediately at the wellhead, to their affiliated company, and that company then goes out and actually sells the gas ultimately to a third party that there's no relationship with. So we need to be careful when the producing company sells the gas to a company that they own and calculates your royalties based on that transaction, because we need to be concerned that maybe they're not charging themselves as much as they could obtain in the marketplace, because by paying the affiliated company less money, they also pay you less royalty. So we need to be careful about that. Now, One way, a company likes to say, hey, wait, listen, we're great guys. Look, if we do that, we are going to give you the local pipeline price, like an index price of the nearest interstate pipeline. Well, that may sound good, but you may find that there's gaps in what the price of your gas is actually sold at when the affiliated company buys it at the wellhead, then takes it out and sells it. The price they sell it at may be higher than the local index price. It could be lower, might be higher. I'm holding in my hand some samples of one single landowner. Now, this is public record. One single landowner, and this is a case that I'm involved in, where we complain that this landowner is getting paid by two different companies under the same exact lease, same lease. And one company is using index pricing, and the other company is not using index pricing. They are actually taking the gas, and they're selling it to an affiliated company at the wellhead. That affiliated company then takes the gas out and sells it at some point in the market. Well, what happens is this one company pays you royalties based upon the price their affiliate obtains in the market. So they sell it to an affiliated company. That company then goes out and sells that gas to a third party somewhere. This company gives you the price that the affiliated company gets out there in the open market. The other company just simply uses a local index price. Here's some examples. Now I'm going to look. Sometimes the index price can be higher, but as a general rule, from my experience to date, that's not what I have been finding. And here's some examples. Now look, I'm pan-picking some more extreme examples, but here are some examples where one company used an index price and the other company used the price that their affiliated company actually sold the gas for. So in this case, the first one, point two, the company using the index sold it for $2. The company who gave you the price that their affiliated company actually sold the gas for in this month paid royalties at $3. So $3.09 actually. The next one, index that month was $1.64. The other company sold the gas, their affiliate did, at $2.99. So again here, the index pricing company would pay you $1.64, royalty on $1.64 gas. The company who would use the price that their affiliate obtained in a sale to a third party, they would pay you royalty on $2.99 gas. Probably a big difference. Here's another one. This was also extreme. Now there can be fluctuations, there can be different reasons for this, but this is numbers. So in this month, the company using the index price paid landowner royalty at $3.05 gas. The company paying royalty on the price the affiliate obtained in the market was $6.49. So index that month was $3.05. Gas price sold by the affiliate was $6.49. So more than double. Again, I want to stress, look, there are not always these gaps, but what you have to do is get individual advice, discuss what we see, what we know, and how these different provisions may affect you. But you can see, I hope, that index pricing may not be what you ideally want. Now, maybe it is, but maybe it isn't. And the point is, you need to get to the bottom of it. Do I want index pricing? Do I not? What are the pros? What are the cons? And that's where you need somebody working for you to explain these things for you. It leads into, and I'm not saying to be commercial, but reviews and consultations. We discuss these issues. We break them down. We talk about what you can do realistically, what you can't do, advise you what you need to know, and give you the tools to make the decision on how to proceed. I do those all the time. I do them by telephone. We do them in office. They usually take an hour or two. These are complicated issues that you need specific advice. Listening to the radio show is great. Going to the websites, great. But you need specific advice to make decisions about your situation. So don't take this as specific advice. Take it as an opportunity to understand, hey, there's a lot I need to be thinking about. We're going to talk more about it here in the next segment. More on royalties, royalty language, and addendum when I get back. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I remind you guys again, Susquehanna County, these Cabot multi-unit well consent forms. I really encourage you, give us a call, see if we can help you, do a review and consultation. They can be way more complicated than you think. I saw one this week. I did a review and consultation. I couldn't believe how complicated it was. Again, not always the case, but always you need to understand what you're signing and how this may impact you because, in my opinion, and it says you're changing your lease. So you need to understand that. So give us a call, 570, that or any other matter, 570-307-0702. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, you can always call us, see if we can help you out, 570-307-0702. And remember, always tune in each week at this time on this station for All Things Marcellus. All right, a lot to still get to, so I'm going to jump right in. Here is another royalty example. This is a form agreement presented by a company. In this case, the company that presented it was JKLM Energy. So again, this is their form lease, what they present to you. Their royalty payment provision, in this case, is item number 5, says that on oil and gas, along with hydrocarbon, non-hydrocarbon substances, produced in association therewith, lessee shall deliver as royalty to lessor 12.5% of the proceeds realized. Remember, first segment, proceeds realized, revenue realized. That's going to mean after deductions. Then it says, so proceeds realized by company that are produced and marketed off the leased premises. But this one goes on, and I'm going to paraphrase. I'm going to skip some of this and get to the last sentence. Company, and I'm paraphrasing again for the name anyway, lessee or company, shall sell the production of the well on such terms and conditions as the company in its sole discretion may deem appropriate. Now I'm going to say that again. This is the last sentence, paragraph 5. Lessee, company, shall sell the production of the well on such terms and conditions as company, in its sole discretion, as the company in its sole discretion may deem appropriate. However they deem appropriate, they can sell it. We saw where companies, and I give them credit when they spell it out and say, hey, look, guys, here's what we are going to do. We're giving ourselves the ability to sell the gas at the wellhead, then give you the price we sell it to ourselves at, if we have that in our contract. Then we're going to take deductions from that price, and we're going to tell you. We're going to put it there in front of you so you know. You know. And at least you know. We don't like it, but at least we know. Tell me, somebody, tell me what in the world this sentence means. And this is in the body of the lease. This is how your royalty will be calculated under this lease. 12.5% proceeds realized. And then it says, lessee shall sell the production of the well on such terms and conditions as lessee, being company, in its sole discretion may deem appropriate. Well, what in the world? You get your royalty payments, you're mad, you see a lot of deductions, you see a low gas price. You don't know, does that mean they can sell it to an affiliate? Does that mean they can use index pricing? Does that mean they can sell it to an affiliate and give you solely the price that the affiliate pays to them, and you have not even the protection or backstop or floor of the index price? I don't know. And if you know, well, you might be the only one outside of the company or company employee who does. But at their sole discretion. So I'm just going to assume it's going to be bad. That's what I'm going to assume. Again, that's me. I'm not saying it is. That's me. And then even goes on. It has the next one. And this is, I love this. Item number 6 with a heading. No post-production costs. Well, hey, guys, that's what we're looking for. Hey, Doug Clark, what are you complaining about? Why are you worried about them saying this and that? Right here, we got a no post-production cost provision right in the body of the lease. And it says that there shall be no deduction from royalty payments described above for the cost of production. Well, no kidding. We're not talking about production costs. Those aren't charged to the landowner. So by saying it, all you're doing is presenting evidence that's already a fact, or presenting information, not evidence, but presenting something that's already a fact that may look good, but doesn't really matter, in my opinion. And then it goes on to say that the company lessee may deduct from royalty payments your pro rata share of taxes imposed by any government body on the value of production or the severance of oil and gas from the leased premises. You're listening to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm, and I got to go back over this. So I'm going to do a little bit slower because this is pretty, to me, I find it remarkable. It says as a heading, by the way, all capitals and bold font, no post-production costs. No post-production costs. Now, I am going to read this verbatim because you tell me where this says no post-production costs. There shall be no deductions from the royalty payments described above for any costs of production, including exploring or surveying the leased premises. I'm sorry, that's actually funny to me. Exploring, so they're not going to charge you. They're not going to charge you for exploring or surveying the leased premises for oil and gas, or installing, drilling, completing, equipping, and producing a well. Ladies and gentlemen, that's a period there. Then that's it. That's it for that sentence. So everything it just talked about was production costs, which are not charged to you. Remember, this heading says no post-production cost. That's the heading, all capitals and bold. First sentence only deals with production costs that are not charged to you. Number 2, second sentence, and there are no other sentences. Lessee may deduct from the royalty payments your lessor's pro rata share of any tax imposed by any government body that is levied upon the value of production or the severance of oil and gas from the leased premises. Then there's a period. Then the next item is number 7. Ladies and gentlemen, that heading says no post-production costs. Ladies and gentlemen, there's not a darn thing underneath that heading that says no post-production costs. Then, in fact, the previous paragraph that I've been talking about, number 5, which says royalty payment, says that they're going to pay you 12.5% of, quote, proceeds realized, which is legalese for after deductions, Then again, says that the lessee company shall sell the production of the well on such terms and conditions as lessee, in its sole discretion, entirely up to them, may deem appropriate. Well, if the company then next sentence says, or next paragraph gives you a big heading that says no post-production costs, and the language under there doesn't say anything remotely close to that, I have reservation. I have concerns. How in the world, what method are they in their sole discretion going to deem appropriate for selling my gas? I obviously don't like that, and you shouldn't either. We ran really long the first couple segments, so I'm going to cut this one short. You're listening to All Things Marcellus. We're going to talk more about these royalty. We're going to get into some addendum terms here in the last segment. Man, this is important stuff. And again, please know that this isn't specific advice for anyone. These are things that to point out of why you need to get specific advice. Then understand, can you make it better? And maybe you can't, but understand how it may work. Maybe you make other parts of your lease better. So then it justifies you making the decision to move forward and enter into the lease. Maybe you can't make anything better. Very unusual, but maybe you can't. But you understand what you're doing and you make the right decision. And that's why I say these reviews and consultations have been so valuable to royalty owners, landowners, for every type of an agreement. So I just encourage you, learn what we do. And our client retention rate is so high because I assure you, we're here to fight, work, and do whatever we can for you. That's what we want to do. That's what I will do. And that's what's going to happen. So I'd love to hear from you. Love to see if we can help you out. Remember, I do not, have not, and I will not represent gas or pipeline companies. Love to hear from you. 570-307-0702. But no, we're not done. We got one more segment. Been doing All Things Marcellus since 2010. And we're going to keep doing it. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, join me each week at this time on this station. And I'm going to jump right into it because we have a very short last segment. So, okay, I have a lot of other royalty provisions I could go to, but I want to get to this. And I want to say this is Southwestern, an addendum term that I've seen offered to various people recently. And again, not specific advice, but I'm going to say, I like it. So in fairness, when landowners are given a better shake, let's talk about that too. So we've been talking about deductions, affiliated sales. I like this provision. Again, do not rely on this just because you hear me say this. You need specific advice, but I just want to point out, I like this provision. It's way better than what we've been talking about. So in this case, this provision provides, and again, this is an addendum provision, not in the form, because remember, the form leases are going to allow for deductions and typically affiliated sales and all of those things. So here, check out this addendum language. Royalties shall be paid on oil and gas substances produced and sold from the leased premises without deductions for gathering, storing, transportation, separating, treating, dehydrating, compressing, or otherwise making the gas from the leased premises ready for sale or use. We've talked about that a lot. I'm not going to go there now, but ready for sale or use may or may not mean royalty without deduction. But as of now, if you have that language with Southwestern, most landowners are going to see that they're going to be paid royalties, what the landowner considers royalties without deduction. So that's a good term to have. Not all companies pay it that way, but that's a good term to have. So I'm going to jump a little bit and do some paraphrasing because of time. But here's some other language at the end of this addendum provision. And it's addressing the affiliated sales issue. Okay, so please, I'll repeat it probably, but this gets complicated. So we first have what we call the ready for sale or use language as part of the addendum, which, look, we want to make it as strong as we can, but if that's the best we can do, you could do a whole lot worse. So, okay, so another part of this addendum provision provides that the proceeds from the sale of production shall be calculated based on arm's length sales to unaffiliated third parties. Remember those other leases we were referring to about affiliated sales, index pricing? So this one says that the proceeds of the sale of production, meaning of the gas, shall be calculated based upon the arm's length sales to unaffiliated third parties. So here we get the ready for seller use, and we have this language addressing affiliated sales. Goes on, in the event that the company sells the production to an affiliated entity. So if they sell to an affiliate, let's see what these guys are going to do. In the event that the company sells production to an affiliated entity, the royalties payable to the landowner, royalty owner, under this lease shall be calculated based on the greater of the price paid by the affiliate. Now that's like the other one, but let's see what part 2 is. Or the price obtained by the affiliate based on the affiliate sale. That's based on the sale of such production to an unaffiliated third party. To an unaffiliated third party. So we like that. I do. Now, again, this is general information, but these are points for discussion. There's also a phrase in here, a sentence in here stating that any cost incurred after the oil or gas is delivered into the interstate pipeline may be deducted. Now, my opinion, that's okay. That's okay. What we're shooting for is no charges or deductions for the cost from the wellhead to the interstate pipeline. Once it's in the interstate pipeline, if it's not sold at that point and it's transported to New York, Maine, Canada, Alaska, wherever, then those transportation costs, that's in my opinion reasonable to be deducted. But we don't want to have those deductions from well site to the interstate pipeline. So this lease, instead of saying, well, if we sell to an affiliate, we'll give you the index price at the nearest pipeline point, this says, no, if we sell it to our affiliated company and that company goes out and sells it to a third party that's no relation to any of us, meaning the companies, then we'll give you that price. I myself like that. I like that. Maybe you don't. Maybe some people don't, but I do. And this is a great example of the different ways that royalties can be paid and royalty calculation used. Any landowner who is considering a lease or reviewing a lease has to understand these various royalty payment calculation methods. They can be very powerful as far as how they change what royalties you're going to receive. Meaning that an index price may in a given month be $2, but the actual sell price of the gas be $3 or $4 or $5. Now, it's possible that the index price could be higher and the gas price be lower, or the sell price be lower. But another thing, and this gets complicated, but another thing that occurs is these companies, as pipeline points come on board and come on board and come on board, the companies have more opportunities to sell the gas at different locations. So the cheapest price may very well be the closest location, and so the company uses that index price to set your price of gas. But they don't sell it there. They sell it at another location, and maybe they sell it at a much higher price. But because your lease allows them to use the index price at the nearest point to your well, you're locked into that price. So if that price is $2 at the nearest pipeline point, that's the average daily price. And then the gas isn't sold there. It's sold downstream, a different location. It's sold for $5, $4. Pick your number. You're going to get royalties based on the index price, not the sell point. And as more sell points open, more opportunity to shop markets, more opportunity to sell the gas at higher prices. You need to be aware of that. You need to understand these various mechanisms and how to make sure that you're doing the best you can for your situation. Okay, we're up against it. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can call me 570-307-0710. 0702. And remember, the landman works for the company, not you, the landowner. And let's stop signing bad agreements. And have a great week, everyone.